Tonight on Capitol Hill, what began as a procedural moment in the Kristi Noem hearing quickly turned into a heated clash over facts, authority, and the meaning of evidence in immigration enforcement. The phrase that set the tone was blunt and emotional. People are hurt on your watch.
People are hurt on your watch.
Gentleman's time has expired. I now recognize...
Mr. Chairman. I ask unanimous consent to enter for the record. One of our colleagues had asked if there was evidence if the so-called Maryland man, Kilmar Abrego Garcia, was MS-13. According to the Attorney General of the United States, she posted that the evidence shows Kilmar Abrego Garcia has repeatedly been identified as a member of MS-13 by a Maryland County Police Gang unit, which I introduced for the record, a reliable confidential informant, ICE officers, an immigration judge agreed, and an appellate board agreed.
Without
so you have is that a court order? Well, I object.
No, she can put anything she wants in the record. She's not complying to your request, Mr. Goldman.
She asked for unanimous consent.
Okay, so you're objecting to her putting that into the record?
I am objecting subject to a clarification. Is that a court order that establishes that he's a member of MS-13?
An immigration judge agreed that he was MS-13.
For bail purposes.
An appellate board agreed.
Don't misrepresent.
Hold on.
A judge.
Everybody pause. We're going to let one person talk at a time. You ask a question. Answer the question, please.
According to the Attorney General of the United States, she informed the country that an immigration judge agreed that your Maryland man, Kilmar Abrego Garcia, is MS-13. An appellate board agreed. ICE officers
you are misstating
agreed.
What
A reliable
Mr. Goldman,
informant.
the clock is not yours right now. She has the floor. Please continue answering the question.
Thank you, Mr. Chairman. A Maryland County
She's not answering the question, sir.
No, she's going to answer the question, and then you can object to her answer.
Make sure that she answers the question?
Finish answer. You just said, please, finish your answer.
A Maryland County Police Gang unit agreed that he's MS-13. A reliable confidential informant agreed that he's MS-13. ICE officers agreed that he's MS-13. An immigration judge agreed that he's MS-13. An appellate board agreed that Kilmar Abrego Garcia, your Maryland man, is MS-13.
Okay.
I object.
Have the floor. What do you want to say?
I object because she is misstating the record and the facts. That is not accurate, and therefore I object to that being introduced. There is no.
Mr.
Sir,
Chairman?
can I explain? You let her go on.
Go ahead.
There is no final court order establishing that he's a member. Maybe he is. So you should put all that evidence before a judge, and if he is MS-13, he should be deported. That's what we're talking about, but you're misstating what all of that evidence is.
No, I think I'm going to make a point here. You basically just read what the Attorney General said, correct?
Yes, sir.
You didn't assert that this was a court order, did you? Did you assert that this was a court order?
I read the Attorney General of the United States.
And you have a right on our committee to submit for unanimous consent or a vote if we want to put it to a vote. This for the record, correct? Is that it?
Yes.
That is correct. Okay,
Mr. Chairman,
she has a right.
Can I review what she is submitting?
No, she can submit something to this committee.
But it matters that she just said she represented exactly what the Attorney General said. She has a document there. I would like to see that document.
Let's make a copy for everybody, and we'll vote on. I'm going to hold on just a second. We're going to hold. You're calling for the question? We're calling for the question. The clerk, we're going to need to set. Hold on just a second. Brief recess.
Please, let's get these on the historical record.
This is great.
We voted in order.
All right, there's
Mr. Higgins, I'm just asking to see the document.
I have the floor. All right, so we have a motion to vote on the submission of this for the record. That's all that has been stated. And
I have a parliamentary inquiry, sir.
Do not interrupt me again. We are on the vote on whether or not this can be entered into the record. A motion has been made, and we will vote on that motion. All of those in
I
favor?
have a parliamentary inquiry before we vote, sir.
Mr. Ranking Member.
It's our request that we object. And in the middle of the objection, you consider a motion, which...
He was done talking about Ms.
No, he wasn't. No, he wasn't. You stopped him from talking.
I just have a parliamentary inquiry.
A parliamentary inquiry. Okay, go ahead. You have the floor.
Is it the procedure of this committee that someone who is making an objection to the admission of evidence cannot review that evidence before we vote on it?
Yeah, the content is irrelevant to the motion, and the motion has been made to vote on the submission for the record.
The content is irrelevant? I mean, that's what I'm objecting to. If she is accurate in what her representation is, I will withdraw my objection. I just need to see the document.
Somebody walk the thing over there and let him read it. I mean, get to the bottom of this quickly. We'll hold on your vote, Mr. Ogles.
Mr. Chairman, given that this is a tweet from the Attorney General that is effectively, I believe, consistent with what Ms. Taylor Greene says, I withdraw my objection.
Gentleman withdraws his objection. I now recognize, who's up? Mr. Jimenez for his 5 minutes of questioning.
Thank you, Mr. Chairman, and thank you, Madam Secretary, for the fine work that you've done. I also want to thank you for approving the members on this side of the aisle, and myself included.
And from there, the room spiraled into interruptions, objections, and a sharp dispute over whether the government has legally established that a man known as Kilmar Abrego Garcia is a member of MS-13. Before we go deeper, make sure you subscribe to the channel so you do not miss any breakdowns of major hearings like this one. We bring you the context that raw clips leave out. What viewers did not see at first glance is that this moment was not just about one individual, it was about how evidence is defined and who gets to decide what counts as proof. A lawmaker asked for unanimous consent to enter materials into the official record, citing statements from the Attorney General of the United States. According to those statements, multiple authorities have identified Kilmar Abrego Garcia as an MS-13 member, including a Maryland County Police Gang Unit, ICE officers, a confidential informant, an immigration judge, and even an appellate board. That sounds definitive, but here is where the tension erupted. Another member objected, not necessarily to the claim itself, but to the legal framing. The key question was simple but powerful. Is there a court order that formally establishes this man as MS-13? That distinction matters because in the legal system, there is a difference between law enforcement assessments and final judicial determinations. Immigration judges operate under a different standard than criminal courts, and bail determinations are not the same as criminal convictions. Subscribe now so you stay informed on how these legal nuances shape real-world policy decisions. As the exchange unfolded, the chairman had to repeatedly step in, reminding members to pause, speak one at a time, and allow answers to be completed. This was not just about decorum, it was about control of the narrative. One side argued that the evidence was overwhelming and had been validated at multiple levels of the immigration system. The other side pushed back, warning against what they saw as misrepresentation and the blurring of legal standards. Here's the part many viewers miss. Immigration proceedings do not require the same burden of proof as criminal trials. An immigration judge agreeing that someone is affiliated with a gang for detention or bail purposes does not automatically mean that person has been convicted of gang membership in a criminal court. Yet politically, those distinctions often collapse into a single talking point, especially in high-stakes hearings like this one. If you want more clear explanations like this that cut through the noise, hit subscribe and turn on notifications. This moment also reveals a deeper political strategy. By repeatedly listing every authority that allegedly identified Garcia as MS-13, the Speaker was not just answering a question, she was building a narrative of institutional consensus. Police, ICE, informants, judges, appellate boards, each mention adds weight, even if the legal implications differ. Meanwhile, the objections served as a reminder that process matters, especially when reputations, rights, and public trust are on the line. For viewers trying to understand why voices are raised and tempers flared, it comes down to this. Immigration enforcement sits at the crossroads of law, politics, and public safety. When officials say people are hurt on your watch, they are not only assigning blame, they are framing responsibility in moral terms, not just legal ones. And when lawmakers argue over what can be entered into the record, they are fighting over which version of reality becomes official history. Subscribe to the channel for continued coverage that explains not just what happened, but why it matters and how it affects real people beyond the hearing room. As this hearing shows, the sharpest battles in Washington are often not over new facts, but over how existing facts are interpreted, presented, and remembered. And those battles shape policy long after the microphones are turned off.